Good morning, everybody. Thank you so much for joining us today for this announcement. We really appreciate it. We're here today to announce agreements with 7 fast food chains that will provide important and significant relief to tens of thousands of low-wage workers here in Washington State, but also, importantly, across our country as well. As a result of an investigation by my office, these 7 fast food chains will immediately end an unlawful practice that restricts worker mobility, decreases competition for labor, and suppresses wages. They're called no-poach clauses in franchise contracts. I'll be talking about those in a moment, no-poach clauses. These no-poach provisions affect thousands of low-wage Washingtonians, and as you might imagine, many, many thousands across our country. I'm joined today by a number of folks from my team and from organizations around our state who are interested in these issues, but I'll introduce a few folks specifically. To my right is Jonathan Mark. Jonathan's an attorney in our office, and he's the head of our antitrust division. And next to Jonathan is Eric Newman, who's the litigation chief for the antitrust division. Also joined by someone many of you know, that's Noah Purcell from my office, and Noah's behind me to my right. Noah, of course, is our Solicitor General. Also joined by Rachel Lauter, who's the Executive Director of Working Washington. You'll be hearing from Rachel shortly, as well as Merle Sherman, an employee of Jimmy John's, and she'll be speaking as well. I just will mention, we really appreciate Merle being here. She does have to be at work here before too long at Jimmy John's, so she may be slipping out a little bit early, so we appreciate you respecting that if she has to slip out a little bit early. Also joined by representatives from many organizations that advocate on behalf of low-wage workers. We have representatives from organizations like Working Washington, UFCW 21, Teamsters, Statewide Poverty Action Network, Puget Sound Sage, Washington CAN, and the Washington State Labor Council. So I'm going to tell you a little about what no-poach agreements are and how they differ from non-compete agreements, just to be clear on that, how they hurt low-wage Washingtonians, why no-poach provisions like these violate the law, and then you're going to hear from the other speakers, and then, of course, we'll take your questions. So late last year, in the fall or early in the winter, I was having a meeting in my office upstairs, and Noah was there, Mike Webb, my chief of staff, was there, and we were really kind of brainstorming about policy issues or legal issues in terms of ways that our office could assist working Washingtonians. What issues are out there? And during that conversation, Noah literally said, hey, I just read a New York Times article not too long ago about these no-poach clauses that are really pervasive in franchise agreements, for example, in the fast food industry, and the negative impact they have on workers all across the country. And so I said, great, I'd love to see it. So we literally printed up, read the article, and we became very interested in this issue as a result. And what we decided to do was to start an investigation to see, hey, do we have these no-poach clauses in provisions here in Washington State? So Eric and Jonathan from our antitrust team began an investigation. They started with contacting the economists who were cited in that New York Times article. That article described these provisions in some detail and talked about how economists are now looking at the impacts on this issue. We knew that provisions like this would violate Washington state law, and in January, after reaching out to those economists, we formally began our investigation by contacting a significant number of fast food restaurants. We focused on that industry first and asked them for information about whether or not they have these provisions in their franchise agreements. Today's announcement addresses 7 of those fast food chains and a resolution of our investigation with those 7. We do, however, have ongoing investigations with the others. And so you can expect to hear additional news from us with those other entities. Let me talk a little about no-poach provisions, which prevent employees. Very basically, what they do is they prevent employees from moving from restaurants within the same brand. So you work at Arby's, for example. If you want to move to work in a different Arby's, you can't do it. You're not allowed to do that under these no-poach provisions. They're found in contracts between the corporate headquarters and the franchises. So unlike a non-compete agreement, it's not between the employer and the employee. right? Corporate headquarters, between corporate headquarters and the franchise. So consequently, most employees have no ideas these no poach agreements exist that limit their ability to take their skills to another Arby's, for example. Evidence suggests that no poach contracts harms workers by putting downward pressure on wages. According to economists, no poach provisions decrease competition, leading to wage stagnation and limited opportunities for low-wage workers. Employees who develop skills at a certain brand would naturally be more valuable to other stores within that same brand. Those employees already understand the products and the systems. Since other locations could not hire those workers, potentially for higher wages, there is no incentive for their current employer to increase their wages either. There's no competition within the brand. This produces an environment where franchises no longer have to compete for employment, for employees, or for talent. This violates, in our view, antitrust provisions found in our State Consumer Protection Act. This statute prohibits unreasonable restraints of trade, which applies just as much to the labor market as it does to the burger market. You cannot restrict competition for workers or talent. So to avoid a lawsuit from my office, 6 companies agreed to end this practice nationwide. Those 6 companies are Arby's, Auntie Anne's, Buffalo Wild Wings, Carl's Jr.'s, Cinnabon, and Jimmy John's Sandwiches. A 7th company, McDonald's, had previously publicly announced, there's been a lot of focus on these no poach provisions, they had previously publicly announced that they would no longer enforce those, but there's no legally binding requirement that they do so. Today, we're now entering into a legally binding agreement with McDonald's as well that binds them to that promise that they made publicly some time ago. So McDonald's is also a part of this announcement as well. So in a nutshell, all 7 fast food companies have signed legally binding assurances of discontinuance. That's a term we use, an assurance of discontinuance. It's a document that we file in courts to assure that a company follows certain rules. These have been filed in King County Superior Court today. These agreements do the following. All these companies immediately stop enforcing any no poach provisions currently in place nationwide, immediately stop adding no poach language to new agreements nationwide, begin proactively removing no poach agreements from contracts with franchises in Washington State. So in Washington State, the 6 companies I mentioned must proactively remove no poach provisions from their Washington State contracts within 120 days. McDonald's must do so in 60 days. For the other 49 states, Puerto Rico, Washington, D.C., the companies must update those contracts as they come up for renewal and remove that language, that no poach language. While that process takes place, they're agreeing in this assurance for discontinuance not to enforce those provisions. That will take some time for them to have them removed, but in the meantime, they are agreeing in a legally binding document not to enforce those provisions. Additionally, the change must notify all franchises or independent franchise owners of the requirements under the assurance of discontinuance. If they violate any of the terms in that assurance of discontinuance, they are subject to civil penalties. So these changes will benefit thousands of low-wage Washington workers, both here in Washington and, of course, many more nationwide. I do want to say that while I'm sure that these 7 companies were probably not excited to hear from Jonathan and Eric when we reached out to them, to their credit, they cooperate with our investigation and have agreed to make this change nationwide. Because they cooperated, they are making no payment to the state of Washington. That for me, the most important thing here was to have this change made nationwide and have that done immediately, and they've agreed to do that. Other fast food companies that use no poach provisions, they know who they are now on the clock to accept a similar deal from my office, or they will face litigation from my office. I expect that we'll reach a resolution with other fast food corporations who want to avoid a lawsuit. If companies do not agree to remove no poach provisions from their contracts, I'm prepared to litigate that issue. Our state antitrust laws are very clear. Businesses must compete for workers the same way as they compete for customers. You can't rig the system to avoid competition. In fact, people often say here now, hey, it's a rigged system out there. People are, well, what does that mean, it's a rigged system? Give me an example of a rigged system. Well, here it is, right? Here it is. You're working at Arby's, you move, or another Arby's offers you a better paying job, gives you an additional $1 or $2 an hour. You go there, but you can't accept that job because of an agreement put in place by corporate headquarters with a franchise that you know nothing about. That's a rigged system that keeps you right where you are and limits your options. We also encourage any workers, because our work is ongoing on this issue, who have been impacted by no poach agreements to contact my office. They can call 206-464-6684 or write to our office as well. But we encourage folks to reach out to us if they've been impacted by these provisions. I'll also just mention briefly this morning I had a chance to talk to a few of my colleagues around the country who are also interested in this issue. There's a lot of interest, I think now it's fair to say, from Democratic attorneys general from around the country, and I look forward to working with those colleagues as we move forward. Lastly, before I turn over to Rachel, my goal is a relatively straightforward one. My goal is to eliminate no poach clauses in the fast food industry in Washington State. That's where we're going. That's the end game. Companies can either get on board with that or they'll face litigation from my office. And if they face that litigation, I do not think that will end well for them. So next, Rachel's going to speak and talk about the impacts that she sees here in Washington State as a result of these provisions. Rachel.
Good morning. My name is Rachel Lauder, and I'm the Executive Director of Working Washington and the Fair Work Center, two organizations merging to become a one-of-a-kind center for worker organizing, advocacy, education, and legal services. I want to thank the Attorney General for his leadership on this and many other workers' rights issues. And I want to also thank the many advocates and labor leaders in the room today for their work and allyship. Alongside our partners, Working Washington and the Fair Work Center have made Seattle and Washington a national example for worker justice. Together, we led winning campaigns in SeaTac in Seattle for $15 living wage and won secure scheduling in Seattle, and we raised the minimum wage and passed paid sick time statewide. Attorney General Ferguson has long been an ally in defending these laws, and by eliminating these fundamentally unfair no-poach agreements, he is taking another step to ensure working people in our state can support themselves, afford the basics, and contribute to their communities. Workers who fight to raise their pay or take on wage theft or other workplace issues are often dismissed and told, go get a better job. No-poaching agreements show that some employers make it harder for workers to get a better job. They make it harder for workers to improve their circumstances. They stand in the way of opportunity. But today that's coming to an end. Thank you, Attorney General, for continuing the tradition of making Washington State a national example for workplace justice. Now to share more about what this really means is Merle Sherman. Merle is a member of Working Washington and a parent, and she is a current employee of Jimmy John's. Merle.
Hi there. My name is Merle Sherman. I am currently a driver and manager in training at Jimmy John's. In the past, I have previous food education experience, including working with middle schoolers, vulnerable youth, and have a degree in social work. My decision to join the Jimmy team was originally just as a driver to be able to ride my bike as a courier downtown. As I wanted to further my career in food education, I decided to go and work with a mass production kitchen like Jimmy John's, working with individuals who have not had previous experience in kitchens before. Give me a second, sorry. So the further I got in the management training program, the more I realized that the majority of the management were only given a tiny chunk of. I was not expecting this.
Take your time. Do you want to just take a break for a second?
Hold on.
That's no problem.
Sorry.
Take your time.
Sorry, guys.
Yep. Public speaking in front of a bunch of cameras is never easy for anyone.
I was not given
Yeah.
previous training. Okay, so let me backtrack. So the no poach agreements, it sounds in its technical form like a reasonable thing. But what that actually looks like is the suppressed pay and limited mobility for those within the company. So as I have previous management experience coming into management at Jimmy John's, there is not mobility for me to receive better pay at another Jimmy John's based on my 6 years experience, previous managing, and work with many diverse populations. A brand new manager that has never had any experience before is given the same wage as somebody coming in with years experience. There are no options for me to go to another store, or have not been an option to go to another store to receive a better wage. All of those have been limited within the company itself and saying that we are only paying 50 cents more, or we are only paying $1 more ever across the board, and I can't go and move and say I want to go work in Ballard where it's twice as busy and I'm still fulfilling a position of being in charge of not just 9 employees but now 14 employees, and I'm being paid the same as a assistant manager or a general manager. I think this is a giant step for those of us who want to use our skills in job training for those that are first-time workers, or those that are fine-tuning their skills in the food industry. And when we go about training those individuals, it requires skills of management, and if you can't pay those of us who have skills to instill confidence and work ethic in those beginning their careers, it's very difficult for us to pay for our families, to afford, because I want to share my skills with those coming into the food industry, and I can't do that if I can't put food on the table. Thank you.
Thank you very much.
Yes.
Thanks, Marley. Thank you.
Thank you. Sorry.
So thanks, Marley. As I mentioned, she may have to slip out before too long to go to work. Just before we take your questions, I'm just really proud of the team. We got this outcome quickly. These are large corporations. They have, as you can imagine, many businesses in the state of Washington all around the country. This is a significant change for them, and especially proud that we were able to get some that, as many of you are familiar with, typically we have an announcement, we're making a change in Washington state, right? But not around the country. I think it's fair to say that this is highly unusual in that all 7 have agreed to this nationwide. And for what it's worth, that has been a condition of an agreement from my perspective. It needs to be nationwide relief if they want to enter into an agreement. And again, want to be clear to others who we are investigating to encourage them to reach a resolution like this with us quickly so we can avoid protracted litigation. With that, I will stop. We'll start with your questions. I'll do my best to repeat the questions. Thank you, Marley. And to repeat the questions.
Mr. Sherman,
Yep.
please, before you run, would you take just a question or two? If we could ask you a question or two.
Do you have time, Marley, for a quick question?
Sure.
Okay. So thanks for being respectful of her time, but she'll do a quick question or two. Go right ahead. This is Essex Porter. He'll be very kind with his questions.
Thank you. First, this sounds really emotional for you. Why so emotional for you?
Food education in general is my niche. It's my passion. It's my career, and it's not just for those who have money. Food and working in the food industry. Those of us who work in the food industry should be paid not only livable wages, but we should be able to transfer our love and our skills, how we work with people and how we produce for the companies that we work for. I want to see youth coming into the food industry excited about being there, paid well for being there, learn the skills that are really truly necessary for well-working kitchens all over the U.S. And that translates into commissary kitchens and the kitchens at UW and the kitchens under Amazon, and this mass production to feed the rest of us requires skilled tradesmen underneath it, and for somebody in charge of training them, I think it's so important to give them confidence in what they do, and possibly to stay in the field for longer and not feel like they have to find something else.
And quick question, with now your freedom to move, what do you plan to do?
Hopefully, my goal is to secure a general manager position at one of the downtown locations. My goal is to prove as manager in training and assistant manager that my skills are truly worth the compensation that I'm asking for, and that I can put a line and say this is what's worth it, and I can bring the sales that is I can increase the sales that that they're looking for, and it's a mutual benefit.
How much more could you make?
Than I am right now. Well, they haven't hit. I don't know how to explain that. The manager and training positions keep my wage and my position as they are until I fulfill inside the position. So the GM positions are based on sales of the store and a separate salary.
Marlee, can you spell your name for Essex and
Yes,
everybody else?
Merlee, and my last name is Sherman, Sherman.
Thank you very much.
Thank you.
Thanks. Thank you very much. So thanks again to Marlee for facing the bank of cameras and speaking to all of you, because really her, we all know this, right? That the most effective testimonials on these issues is not going to be from some guy in a suit, right? It's from people who are impacted by this, and the folks behind me are representing many, many thousands of folks just like Marlee who are facing this really unfair practice nationwide. So I'm going to stop there and turn to any additional questions you may have. We'll repeat the questions. I think there may be some folks on the phone as well, so I'll do my best to repeat the questions, and we'll identify ourselves as we answer them as we go forward. Does anybody have any questions?
So many other fast food companies in
Mhm.
the go. How many other companies do you think you're working with? Do you think you'll be able to bring in?
So the question is, there are many more fast food companies to bring into the fold with this agreement. How's that going? How many do we have outstanding? I guess a couple thoughts on that, Essex. So when we started the formal part of the investigation in January, we sent out we call CIDs. This is requests for information. Companies have to report back to us. I won't give you a precise number, but it's a significant number of companies that we yes, I think that's fair to say. It's a significant number. And so obviously from that, these are the first 7 where we're making an announcement. And, I think it's fair to say that some of the other companies were not as quick as these 7 to reach this particular agreement. But, I want to be really clear. This is only going in one direction. Either they're signing these agreements or Jonathan, Eric, and the team are going to be filing litigation. We think our legal arguments are very, very strong. I think that's reflecting the fact that these 7 companies have entered into these agreements relatively quickly and doing it nationwide. I also think you'll be seeing a group of my colleagues sent out a letter on this issue to a number of fast food chains not too long ago. So there's an interest, and I spoke to a few of those AGs earlier this morning to give them a heads up of this announcement. They immediately expressed their great interest in working together if we have to move towards a litigation perspective. We hope it doesn't come to that, but it wouldn't surprise me, But it's going to take some time. But the goal, to be very clear, is the complete elimination of these no poach clauses from all franchise agreements in the fast food industry here in Washington State. That's the goal.
You said this does not affect the typical non-compete agreements that keep employees from going from one company
Right.
to another. But isn't the principle the same here? Shouldn't employees have the right to change companies if they can get a better deal?
So that there is, and that is a separate conversation, which is an important one. And some folks here have thoughts about that. There has been legislative proposals down at the state capitol. You may see another one this upcoming session. But I talked about non-competes just to make sure we're clear what no poach is different than that. I'm not suggesting those are free from all problems, right? Far from it. But what we're talking about here is something that is a very different entity, which is also to emphasize most workers have no idea they're subject to this. They have no idea at all. And often workers only realize it if they actually get an offer from another store within that brand, or they seek one. So that's why we encourage workers to contact us if they run into this problem. And Brianna, I'm not sure if we have folks on the phone. Should I open up for any questions that folks may have on the phone if there's anyone there? So I'll open up to anyone on the phone who may have a question. If not, we'll just wrap it up here and take questions one-on-one here. Does anybody have any questions on the phone? If not, what's that? Oh, unmuting everybody. Got it. Okay. So we're going to give one last chance. There's a number of folks here on the phone. Does anyone on the phone have a question for us?
Yeah, hi, this is Heidi from Cantor.
Heidi? Oh, hey, Heidi. I'm going to try and turn you up here. Hang on just one second. Okay, go right ahead.
Can you speak to any actually follow through with these agreements?
Heidi, do you mind just repeating that one more time? I just want to make sure I heard that right.
Can you explain any sort of enforcement or follow-up that there will be to make sure that the companies comply with the agreement?
I see. Yeah. So, a couple thoughts on that. So, as I think I mentioned, agreements are being entered into court in which they agree to these terms, that they will not enforce these provisions and they will eliminate these provisions. This is a common mechanism for us in any sort of antitrust consumer protection context. And a company would be putting themselves at tremendous legal risk if they were to violate that in the future. We would become aware of that. A worker would let us know. There'd be a complaint. And once you have this assurance of discontinuance already filed in court, as you might imagine, it makes any future legal case much, much easier to bring because they've already agreed to no longer go forward with that conduct. So like all of our assurance for discontinuances, we obviously monitor those. We monitor any complaints we receive about any issue we have that's related to an discontinuance, and that'd be no different here. That said, I would not expect problems with these companies. I mean, when you sign on the dotted line, this thing, you know what you're getting yourself into. You are communicating to a court. You're legally bound by this, and it'd be a big mistake to violate that. Anybody else on the phones have a question?
Hi, General Ferguson. This is John Steingart with Bloomberg Law.
Hello.
You said you filed some papers in court. Could you share those? Could you distribute those to us, please?
Yes. So Brianna is my communications director. Is saying that those are in the press release. It's embedded in the press release. Is that the idea? So they're embedded in the press release, which should be on our website right now. She's nodding her head. So those should be available. And so what you'll see is 7 of those. We call them AODs, as shorthand for an assurance of discontinuance, filed this morning in King County Superior Court. So those have been filed and signed.
Okay. Thank you.
Thank you. Anyone else on the phone who has a question?
You said thousands of Washingtonians. Do you have any more specific number of how many employees there are at these 7 businesses in Washington?
I believe in our press release we identify, correct me if I'm wrong, Brianna, how many for these 7 chains, how many businesses they have in Washington State. I believe that's identified, but we do not know, as you might imagine, the specific number of employees that each of those businesses represent. So that's why we're giving a relatively broad number. And of course, you talk nationwide, it's it's a huge number. But no, we do not have a more specific number. The companies themselves could provide that to you, I'm sure, right, and tell you how many specific employees they have in a particular state, for example. We don't have that number, but we did try to provide the number of businesses, for example, how many Jimmy John's are in Washington State, and that's in our press release to give you some sense of those numbers. Anybody else on the phone have a question? If not, we want to thank everybody on the line who joined us today. I want to thank everybody who's joined us here for this press conference, for this we consider to be a really exciting announcement. This issue has received a lot of attention recently, and rightfully so. And this is precisely the kind of work that I envision for this office to do. If you are someone like Merle, how are you going to take on a large corporation and fight something like this? It's pretty tough, right? It's pretty tough. So the AG's office is really the people's law firm. That's what we're here for. We have folks like Jonathan and Eric and their team in the antitrust division, the professional staff and the lawyers who can bring a case like this or start an investigation, require companies to provide the information to us and move forward. So I want to thank as well everybody else in different organizations for the work that they do day to day that helps inform us on the work that we do, and we look forward to hopefully having additional announcements on additional companies coming soon. Thanks so much, everybody. Really appreciate it.